The U.S. government can still continue to work with social media companies to flag and suggest taking down misinformation. And no, that does not violate your First Amendment rights. At least not yet. So says the Supreme Court in a 6-3 ruling written by Justice Amy Coney Barrett and released today. Justices Alito, Thomas, and Gorsuch dissented, so I'll explain their position in a second. But first, 5 social media users and 2 states sued the federal government, claiming during the pandemic, the FBI, CDC, Homeland Security, White House, and Surgeon General, just to name a few, colluded with social media companies to stifle free speech by suppressing or removing COVID-19 information or election information that the government said was misinformation. The government argued it has worked with social media companies for years to promote responsible actions to protect public health, safety, and security on the internet. Plus, the government said in the end, whether action is taken on a specific post or account is the sole discretion of the platform based on its own community guidelines. Well, today, the Supreme Court sided with the U.S. government. The ruling didn't even discuss the First Amendment questions raised because the justices found the plaintiffs did not even have standing to bring the case in the first place. The majority opinion goes through each of the plaintiffs and their arguments and says their failures to prove standing are simple and basic. The plaintiffs fail, by and large, to link their past social media restrictions and the defendants' communications with the platforms. They do not point to any specific instance of content moderation that caused them identifiable harm. The ruling says social media companies are private businesses and they have the right to suppress certain categories of speech. They can place warning labels on some posts, they can delete others, and they can also demote content if the post violates their content moderation policies. Sure, the government flagged some posts and accounts, but the Supreme Court ruled evidence indicates that the platform had independent incentives to moderate content and often exercise their own judgment. In the dissent, Justice Alito calls this case one of the most important free speech cases in years. He says, obviously, private entities are not subject to the First Amendment, and they may publish or decline to publish whatever they wish, but government officials may not coerce private entities to suppress speech. He acknowledges that some of the online information posted about COVID-19 and the election especially were undoubtedly untrue or misleading and downright dangerous. But he says what the government did was equally as dangerous because he says it was more subtle and covert. He writes, it was blatantly unconstitutional and the country may come to regret the court's failure to say so. Now, this is going to become very important as we move into the 2024 election. Social media companies are already talking about their election misinformation rules and plan to vigorously enforce them. And at this point, the Supreme Court says that's absolutely legal and not violating your rights. But we are still waiting on 2 more huge social media rulings from the Supreme Court that have to do with content moderation. So if you want to read this ruling and the dissent for yourself, I will email it out to you tonight in my Newsgirl News Roundup email, so make sure you sign yourself up.